Yes.
Yeah. Ms.
Yes.
Myers, did you
Yes.
file a response here?
We did not file a response. I was
Okay.
just retained. I
Okay.
did.
All
Yeah.
right. All right. No problem. I just wanted to know. I just wanted to make sure.
Yeah. Yeah.
Yeah. All right. So we are here in the matter of Jameson versus Busuk, case number 23-06095 DM. Sir, this is your motion. What is going on with your income?
So actually changed jobs. I switched from another tree company that is
But
basically doing,
you're still doing tree work, correct?
yes, yes, sir.
Why did you switch the jobs?
The winter work slowed and it looked like he was going to go out of business, so I took up other opportunities.
And it's a little bit less pay, but not much less pay, correct?
Yeah, it's $3 less an hour.
Welcome back to court, folks. Today's case, Jameson Veers Buzaus, number 23-06095 DM. We've got a dad in tree work who says winter slowed, switched jobs, and took a pay cut, right as a $10,000 arrears cloud hangs overhead. The judge is laser focused on one thing. Was this job change voluntary or unavoidable? Meanwhile, the mother's attorney says the old employer is still operating and raises a red flag about income withholding not kicking in. That's the engine that's supposed to pull child support straight from paychecks. Was this a paperwork mess or a strategic dodge? Stay sharp. Major questions about imputed income, arrears, and a possible warrant land on the table.
Um, Ms. Myers, any input on this? I mean, I've always had problems with, lawn services because they do go in and out of business. And, sometimes if you see the handwriting on the wall, normally if somebody leaves their job through no fault of their own, or through fault of their own, I kind of hold them to the old income. The problem is this is not one of those jobs that is continuous or steady for the most part, at least in my experience. So
It's my understanding that he voluntarily,
I understand. Yeah,
yeah,
voluntarily, but if he's got evidence that, possibly he was, he wasn't getting any work, that doesn't help.
no, that's not the case. Actually, he just moved on to a different job. The company
Right.
that he worked for is still in business. It's been in business for quite a while. So it was more an issue of he recently got called into court because he's 10 grand or whatever behind,
Right.
and now he all of a sudden has a
Well,
new job.
considering if you're saying that he was steady there and he's 10 grand in behind, my question would be this, because we take the money from the employer, not from the parties, which means if there's a steady income, why would there be an arrearage?
Here's your first legal hinge. When a parent voluntarily leaves a steady job for lower pay, courts often impute income, meaning they calculate support, as if the old wage still applies. The judge even says he holds them to the old income, unless the exit was through no fault of their own. Tree and lawn services can be seasonal and unstable, but that cuts both ways. It explains fluctuation, yet also raises the question, why leave a still operating company? Viewers, what do you think? Does winter slowdown justify switching to a job that pays 3 hours less? Or should support stay tied to previous earnings? Drop your take. Fair adjustment or self-inflicted pay cut?
It's my understanding that there was an issue with the income withholding order, and
Okay.
my client did bring it to the attention, but just so the court also is aware, Mr. Jameson has been very vocal about the fact that my client would not get money. And there were some
Well,
discussions between him and the employer.
right. Okay.
And I haven't seen
Yeah.
an income withholding order at all, even go out
You,
to
you
it.
you won't. The income withholding orders go only to the employer because of
Right.
because of the information contained within them. It's kind
Right.
of personal, and that's why the court never sees an income withholding order either. Because
So,
we don't need it.
I'm,
This was just
I'm
recently entered. That's why I'm trying to. Well, actually, it's been almost 2 years, correct?
correct. 2023. When was your, yeah,
Yeah,
my date of birth.
2023. It
Yeah.
was it was fall of 2023. Sir, how long did you work at that place?
I would say about 3 years. And in January, he told us that we were going to be laid off until March. And that's when I looked for another job. Went
Do
through
you have it? Do you have that in writing?
Yeah, I can probably find a text from.
Then I will need to see that.
Yes, sir.
And it's going to hinge on, because if he was told that they were going to be closing down for 3 months, that would give him no income, ma'am, and searching for another job would have been appropriate. But like I said, that's why my first question is, what's going on with your job?
Yes, sir.
So I expect you to get to me. And Ms. Myers, have you been on this case before?
The judge hits a crucial point. If there's steady income and a proper income withholding order, IWO, in place, arrears shouldn't balloon to $10,000 so easily. It was direct the employer, not the parent, to send support. If the employer never got the order, or got it and didn't comply, the money trail breaks. Mother's counsel alleges 2 things: a withholding snag, and that the father was vocal about her not getting money, possibly tied to conversations with the employer. That's serious. Audience, is this a bureaucratic failure or intentional obstruction? If a working parent had wages all along, where did the chain fail? Court processing, employer compliance, or party disclosure?
I have, Your Honor.
Yeah, you have.
Yeah.
So, sir, you have her contact information. I suggest you get her a copy of that text.
Will do.
We're going to set this for a settlement conference in the next 2 weeks to determine, that way I can look at it, Ms. Myers can look at it, we can sit down, and if there's a justification here, I'm willing to give some leeway. Because let's face it, in another 12 months, he can probably ask for a child support review one way or the other. But the idea is to make sure that we get that money flowing. So bottom line, sir, regardless, you need to contact the front of the court with your job change to inform them where to send the new income withholding order to, so you don't become more and more in arrears.
And
Yeah.
this week we did put in a withholding.
Okay. To your new
So
employer?
Yes, sir. The first withholding came out this week.
Good. In that case, then the money should start flowing, Ms. Myers, and then we'll find out if it's appropriate to adjust.
Evidence time. The judge wants written proof. A text from January showing a 3-month layoff. If the old employer told workers they'd be off until March, then finding a new job is reasonable mitigation. If not, the move looks voluntary and could trigger imputation at the higher rate. Smart move by the court. Schedule a settlement conference in Alecam. 2 weeks, get the text to opposing counsel and the judge. And meanwhile, the father must contact the friend of the court to route a new IWO to the new employer. Viewers, how would you rule if the text confirms a 3-month shutdown, approve the adjustment, or stick with old income?
Because I also had a question as to, I believe she was held at 0 income. Why was that? Is your client
Actually, I think
disabled?
she was imputed. She provides all the childcare, Your Honor, so that Mr. Jameson, it's the way that their marriage was set up as well, so that Mr. Jameson can work.
Right.
So he can work anytime he wants, which is why I was also going to bring up the fact that he works significant amount of overtime as well.
Understood.
So yeah. So there's no.
That's why I'm questioning this. I'm not making this an automatic.
Right, I understand. Thank you.
Yeah, no, she was held at 0 income. That's
And
also.
I think it's because the decision was either 0 income and then we do something with childcare, or we impute her. Because if she goes to work, obviously childcare is going to be much more expensive. They have 4 children, 4 young children.
Understood. But, looks like this was part of the agreement of the parties back then. All righty.
It was.
But I will look at this, because neither party may like what's going to happen at the new review, because they changed the guidelines again, so that it might not work for either party, and I'd rather not hurt either party either. But I also want to get it correct, because let's face it, like I said, when we find it incorrect, we find it imbalanced, and then nobody gets any money. It just winds up chasing tails, and that's not worth it. So what's your question, Ms. Myers?
One other thing. So we're going to come before the court in September because my client is currently pregnant and due. So there would be a change in September, either way.
Oh, okay. So it may be that we have to look at it now because of his change, if it's an appropriate change, and we'll have to look at it again in September when there is another change. Okay. But her birth, if she's held at zero income, ain't going to change anything. So unless you want her imputed and that income then offset by her new child, that's fine. But if she's at zero and stays at zero, birth of a new child won't change the mathematics here.
Right.
You have to have income to deduct from. And since the party set this up at her at zero, you don't have a change of circumstance from that one.
Yeah,
You could ask for it, but be careful again what you ask for.
Right. I'm just trying to get my client some money because there is such a huge arrearage. I think there might actually be a warrant too that might be.
That's why I'm warning him, and that's why I'm going to look at
Mhm.
this a little bit more closely to make sure that
Thank
we get it right.
Thank you.
Okay. Again, that's what we find out. That happens if you set child support incorrectly. Now, again, why there's been a kind of continuous employer up till a couple months ago, $10,000 should not have happened that easily. Is it that there was a back order to it too? No? Okay.
He just wasn't paying, and
Again, he doesn't pay. Income withholding
Right.
orders pay. That's why I asked him. He's been employed there since before the inception of this. There should have never been an arrears, so something happened with a paperwork screw up somewhere.
I understand, but I think there's some nefarious things going on behind the scenes. Whether or not Nick provided the actual information in regards to his employer, whether or not he had a deal with the employer not to pay, and my client has been on top of it,
the employer would not like that because there is case law out of Kent County where they took an employer to task. The employer not only had to regurgitate all the funds, the employer had to pay fines, penalties, and it was Fifth Third, and it was not pretty. We're talking into the millions.
Big policy moment. Mother was imputed at zero because she provides full-time childcare for 4 young kids. Courts often weigh whether forcing a caregiver to work simply pushes costs into expensive childcare, which can cancel out earnings or even raise overall costs. Counsel also alleges the father works significant overtime, which, if consistent, can factor into support. The judge signals caution. Guideline changes may hurt either party in a new review. Question for you. Should a full-time caregiver of 4 young children be imputed income at all? Or is zero with childcare trade-offs the realistic and fair baseline? And how should courts handle fluctuating overtime? Average it, exclude it, or count it fully?
Right. And my client did contact her worker to try and sort that out. It's just never been sorted out.
Okay. Well, we'll see if we can sort it out better this time.
Perfect.
And hopefully we've got an income. Well, hopefully we'll know if there's an income withholding order in place, and then she's getting her money from the new employer. And this job, Mr. Jameson, is continuous now?
Yes, sir. Yes, sir.
Okay. Yes, Ms. Myers?
There was supposed to be, last time the parties were in court only a few weeks ago, maybe a month ago, February, 2 months now. Mr. Jameson had indicated that he had filed his tax return, so had told the court at that time on the show cause that there would be money forthcoming in that regard. It's my understanding that he's withholding filing his return.
Well, that's between him and the federal government. That also has consequences and penalties. So, yeah, normally if there's an arrearage, it's my understanding the IRS sends out the letters in August to prepare for the end of the year, and then they set up the confiscation of any type of tax return. So we'll see what happens. Yes, sir. Yeah, Mr. Jamerson.
So I had texted her telling her that I had filed my taxes, which I did. And then she told me that she had claimed the other 2, which I don't really know how taxes work. So I was assuming that she got the money for the 2 per the court agreement.
I don't know.
So, and the only reason
if you're following, that doesn't go against your child support. That's her taxes, just as your taxes are your taxes. Okay. All right. So we'll see each other again shortly. My clerk will be contacting you to set up a short, quick, and I suggest you get that any type of paperwork to Ms. Myers and myself so that we may have it to review for the settlement conference, sir.
This is a thunderclap. Counsel suggests nefarious behind-the-scenes conduct, like the employer not honoring a valid IWO. The judge references case law where an employer got hammered, repaying funds, fines, penalties into the millions. Translation: employers who ignore IWOs can face serious exposure. The court's priority is practical. Get the new IWO in place, confirm continuous employment, and start money flowing now, then fine-tune support at review. For viewers, here's the takeaway. If you owe support, your safest path is transparent employment info and cooperation with withholding. If you're owed support, document every payroll issue and push for enforcement. Have you seen employers mishandle IWOs?
All right.
Thanks, sir.
Good luck, everybody.
Final layers. The court notes tax intercepts often sweep arrears from refunds, but withholding is still the backbone. Father claims he filed. There's confusion about who claimed children, yet the judge clarifies. Tax elections don't reduce support owed. Where does this land? The court will review proof of layoff, verify the new withholding, and reassess support under updated guidelines, with eyes open that neither side may love the math. Key takeaways: 1. Document job changes. 2. Ensure IWOs reach the current employer. 3. Expect imputation if a pay cut looks voluntary. 4. Childcare burdens matter when setting the other parent's income. If you found this case as shocking as we did, hit like, drop your verdict in the comments, share, and subscribe for more jaw-dropping courtroom breakdowns.